The FY2027 H1B CAP registration window is set to open at noon Eastern Time on March 4, 2026, and will close at noon on March 19, 2026. For those eager to secure an H1B visa, this 2-week period is critical, as it serves as the first step in the application process. Each registration is associated with a specific employer and employee, and at the end of March, USCIS will conduct a lottery to select from the numerous registrations submitted. Those selected in the lottery can proceed to file their full H1B petitions during a 90-day window starting in April. It's important to note that additional filing windows may occur later in the year, although there is no certainty regarding these future opportunities. For more detailed discussions on related topics, such as the CAP rules impacting F1 and optional practical training, OPT, students transitioning to H1B status, please refer to our website. The registration process will be significantly altered for 2026. All registrations must now include vital beneficiary information, along with the Standard Occupational Classification (SOC) code, the Occupational Employment Statistics (OES) wage level, and the area of employment tied to the offered position. This information will influence the selection process, with beneficiaries receiving a number of lottery tickets equivalent to their wage level. For instance, Level 4 positions will garner 4 tickets, Level 3 positions 3, Level 2 positions 2, and Level I positions 1. This structure means that higher wages will enhance, but not guarantee, the likelihood of selection. Contrary to earlier proposals that faced legal challenges, the current regulations do not eliminate lower wage candidates. Rather, they adjust the selection odds, reducing the chances for those in Level 1 or 2 positions when compared to higher wage roles. The revised rules will take effect for the registration period in March 2026 and influence all subsequent CAP seasons unless further revised by new regulations or court decisions. In terms of specific registration requirements, the new process mandates that registrations include the SOC code, the OES wage level, and the designated area of employment for the job. These wage levels will significantly impact lottery selection probabilities. If multiple employers submit registrations for the same beneficiary, USCIS will utilize the lowest wage level indicated across all registrations for lottery purposes. This represents a shift from past seasons, where employers could submit registrations with minimal detail without evaluating wage levels, job duties, or job relevance. Now, all these factors must be meticulously assessed to ensure compliance with the new registration rules. Job titles, education qualifications, and experience requirements are all impacted, which obligates employers to classify offered positions accurately and support them with the appropriate SOC codes and wage levels. Employers also need to be conscious of the $100,000 fee applicable to all approved H-1B petitions under consular processing. Concerns regarding wage levels post-selection are significant. If a petitioner's H-1B CAP petition is approved under a specific wage level, it is crucial to maintain that wage level in subsequent H-1B filings. Lowering the wage post-selection could raise red flags with USCIS, prompting thoughts of strategic manipulation of the lottery by the employer. Furthermore, USCIS reviews filings from related entities to ensure that job offers are genuine and not designed to exploit the lottery system. If inconsistencies arise between the registration and the full petition, USCIS may deny or revoke the petition upon finding discrepancies in job duties, SOC codes, worksite locations, or wage levels. Approval can also be revoked if it is determined that the terms of the petition were violated. Employers must be vigilant. If 2 companies file H-1B registrations for the same candidate, only one can proceed if the jobs are identical. Additionally, if changes to the worksite are necessary, they should be consistent with a bona fide job offer. It is generally best to keep the worksite the same between registration and petition for clarity and compliance. Attempting to manipulate the H-1B lottery system can lead to severe consequences, including petition denials, criminal referrals, and lasting repercussions on an employer's capacity to sponsor foreign workers. Therefore, the best practice for employers is to ensure that job offers, wage levels, locations, and job duties articulated in the registration are precise and sustainable throughout the employment period.
If you would like Tiwari Immigration Law's help on your immigration filing, please email us at info@tiwari.com. Our attorneys are licensed in New Jersey and represent clients on immigration matters in all 50 states. This video is for informational purposes and should not be considered legal advice. Speak to an immigration attorney before applying this information to your specific case.